Everyone signed up for a tool thinking it was shiny bells and whistles. It's going to increase operational efficiency. It's going to reduce overhead costs. It's going to be magic. But they don't know how they work, which is a problem when it comes to explainable AI. You cross the line in being a deployer if you wrap your logo around it and it's sitting on top of chat. You become a deployer. You now have additional obligations. And so at any one time, whatever I put into the chatbot may be shared with one of three or all three foundational models. You don't want to tell consumers that I asked OpenAI and Sam Altman told me to pound sand when I asked for the model weights. Like, it's not something you want to put in your disclosure notices, but you do want to tell them as much information as you have.
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CTOs and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, so we've got Heidi Saas here today. She is an attorney licensed in New York, Connecticut and Maryland with over 18 years of experience in consumer rights, 6 years in data privacy, and 3 years of ethical AI and governance. She holds a CIPP US and works with CEOs, CTOs, DPOs, or CMOs of companies across different industries on compliance strategy, privacy program design, or risk management. Heidi can go pretty deep in terms of technical scrutiny, if I can call it that, of AI or software as a service tools, and that comes very handy when approaching today's topic, which is a high-level understanding of AI compliance for vendors and their enterprise customers in the marketing technology space, or MarTech. Let's go for it. Heidi, thanks for joining me.
Thanks for having me.
We are talking about AI, and we are very concerned, or I am more worried about SMEs, small companies that are deploying AI or using someone else's system for chatbots and whatnot. Can we zoom out a little bit, and how do you see the wider spectrum of AI as it applies to companies before we enter into governance?
That's a great question. Thanks for having me on. My name's Heidi Saas. I'm a data privacy and technology attorney. These are my personal opinions, not legal advice. And that question is important, I think, when dealing with businesses, because everybody is looking at generative AI as if that's what people mean when they're talking about AI. But artificial intelligence has a long history. And I think it's a good idea to take a step back and find out, where is the line? Machine learning is not the same as deep learning or neural networks. The generative AI, those are neural networks. They are using a massive amount of data to try, and it can be unstructured, and they're using this to try to generate new data. Machine learning is a prediction machine, like a recommendation for which song you want to listen to next, those sorts of things. When we're talking about AI legislation and regulations that apply, they apply to some of these tools as well, some of these more simple machine learning tools. Now, historically in our country, we have had problems with discrimination. So when people automated these systems, our problems with discrimination didn't go away. They get automated into some of these systems. So even though it is a hiring tool, for example, that is screening resumes, that is still a tool that needs to be regulated by AI legislation. In fact, it is almost imperative that we regulate these particular tools because it relates to the freedoms that humans enjoy and need to exist. You need a job, you need a place to live, you need education. These areas are called consequential decisions in the new legislation that is coming out all over the world, mostly because the lobbyists behind the larger foundational models have said, why don't we limit the rules to just these narrow things where the harm to humans is the greatest risk area? I don't know that that's going to address the issue because it only takes the heat off of the foundational models for a little bit. But there's also a question of the complexity here because it's a little easier to get into some of these machine learning tools than it is to try to find what are the weights and probabilities in the parameters of the right of all the foundational models. Those are going to be really hard to get into. So we can write laws, but that doesn't mean that we can implement them if it doesn't map well to how the technology actually works. So I think we've gotten way too far ahead of ourselves in trying to regulate some areas of things when we've got basic problems that have been in existence for a while before AI was even popular. So let's take a step back and start with all of the tools that we have instead of just thinking it's not Gen AI, so the regulations don't apply.
Very good, thank you. So we've got the basic tools that we've had for a while, and we also have the basic legal tools to fight against deceptive, unfair practices, even before we had any AI framework. So, and we also have the basic principles. So how will you get started before we even differentiate? So Gen AI or again, basic machine learning. How will you then approach this, for example, with that toolkit?
When I go into a business and start looking at their tools, I look at their tech stack and what I can see from the outside before I talk to them. That helps me decide if I want to talk to them, and if I do want to talk to them, what approach I want to take. Then when I talk to them, I want to talk to them about the utility. First of all, do you know what tools you have in your tech stack? Because you had to take time to integrate that. And somebody did. Maybe they're still gone or they're still there. I don't know, but somebody integrated that into your tech stack. Do you use it? What's the return on the investment that you're getting from using that tool? What are the risks that are involved in using that tool? And are there alternatives that you can use as opposed to sticking with the tool that you have? For my basic approach is privacy by design is a luxury practitioners don't often get. It is more privacy by retrofit. Also the same with ethics, because the tool is already there and you take the tool as you find it, and then you do what you can to mitigate the risk or swap it out for a better tool if you can't mitigate that risk, or whatever you need to do to move forward here. But it goes on a tool by tool basis. What is this tool? What does it do? What are the inherent risks? And what are we going to do to address that? Now, thinking out of the box, you would hope that an organization would have privacy impact assessments already completed. This goes back to the do I need to categorize this as an AI tool or not kind of question. And it also comes to a gap of knowledge between practitioners in some instances where they just don't have the technical skills to look at the stack and find out where risk lies. So maybe they don't have a DPIA already done. Well, the next question is, why not? And what can I do to assist you with that? And, those sorts of conversations. You don't want to throw shame at people for things they don't know, but you do want to help try to raise the base level of knowledge across industries by highlighting the risks that are inherent in these tools. Everyone signed up for a tool thinking it was shiny bells and whistles. It's going to increase operational efficiency. It's going to reduce overhead costs. It's going to be magic. But they don't know how they work, which is a problem when it comes to explainable AI. And they're not necessarily cognizant of the risks that it imposes on humans when these tools are not properly supervised. They need to be audited. They need to be supervised. Algorithms, these models, there's drift. Just like there's scope creep in a contract, there's drift from the model, and if you are not paying attention when the drift happens, then you can get to a point where now you have obligations to disclose how sloppy your tool is to the regulators. So I mean, it's getting to a point where people are starting to understand you can't just look at the shiny bells and whistles on the outside. You really have to get in to find out exactly how these tools work so that you can properly assess the impacts on privacy.
So I see two parties to this. The startup or the, maybe not a startup, the software as a service company. In our case, we tend to see lots of marketing technology suppliers, vendors. And then there's the other side, the other party, which is the company buying the tool. Maybe they do not even know what they have. As you're saying, you need to go and see what's there or what's real. And so if we start with the first one, what do you see is out there, and in which order will you tackle it in terms of the framework that applies to a vendor that claims to or actually applies any kind of AI?
I love marketing people and I love all these great marketing tools. I know I say I hate data brokers, and that's true, but I love marketing people. And here's why. They are the canary in the coal mine. They are creative, they're smart, they're on the cutting edge of doing new things. They are not thinking about legal consequences when they do it. So it keeps my people super busy because sometimes we have to undo what the clever marketing people have done. So I keep my eye on marketing. What are they doing now? How are they doing that? I see this problem coming soon, right? A clear example that I can give you is a recent class action case that was just filed against Twilio. Okay. Identity verification and identity resolution are not the same thing. So the small business has an app and they need to make sure who's getting in my app. So they put Twilio in there, and the consumer thinks they're adding their phone number for Twilio to check their phone number and then grant them access into this app. What's really happening is Twilio is swiping every bit of data they can get out of that person's computer and adding it right into their identity graph system for targeted marketing and then selling those insights, right? So yes, and the consumer has no way of knowing that that is what Twilio is doing. That's how much data they're snatching because they don't even know that Twilio is in the background. They just see a place to put in their phone number for the app, right? And if you look at the privacy policy, it may or may not say Twilio is going to collect your phone number for identity verification purposes, and this is part of our security and blah, blah, blah. Once again, privacy crimes are being done in the name of security, but people, the problem is the crime of disclosure. You didn't disclose it or give them an opportunity to opt out of the use of this data for marketing. And so now the business that is just trying to do the right thing by making sure unwanted persons are not accessing their app is now on the hook for integrating this app called Twilio because they thought it was for verification when really it's for identity resolution. So that is going to be interesting to watch how that goes because Twilio is going to say we shifted liability to the user of our app and we're not responsible for anything. We're just doing a service over here. The business is going to say, how are we supposed to even know you were swiping all of that data when we thought there's one field for a phone number? And that's all we thought you were taking. So, I mean, in this part, you've got misrepresentations and misunderstandings between the service provider and the business. And who's left hanging in the balance? The consumer, right? And so that's a good example of how what you think this tool is doing is supposed to serve one purpose, but it is actually opening up a huge swath of liabilities for you if not properly addressed and disclosed. Also, downstream use of this data by Twilio to other people, right? Is it anonymized when they do that? Is it, clear text? Do they not even care? Because if nobody knows that you are doing it in the secret depths of the backs of the computer, then why not do everything that you can to make money? Make hay while the sun shines, as they say. But in this case, I think the sun is no longer shining on the dark procedures and data snatching that is happening in the background of some of these apps. So that's a challenge that businesses need to address. And sometimes it may take more than just looking at what the privacy regulations say, because I believe the true risk area in our practice field is consumer rights, at least in this country. So you've got privacy, and they don't have private rights of action. The consumer rights laws do.
Yeah, it'd be good to know where that leads. So if we now take it into AI, we have the same scenario. You've got things that you don't know your tool is doing. that could be dragging you into a class action or into responsibility, even in the case, for example, of a data breach, right? So how do you see that when once they are AI powered and now you start buying these tools, you embed them into your code, you as a data controller, and how can you help them, or how would you help a company that buys a tool such as this comply with AI regulations?
Procurement is a minefield right now. Luckily, I have trusted professionals and academics that have been working in this field for years and have written guides on how to go through a process of procurement to make sure that you've ticked all the boxes of things that you are anticipating. But as we know, these systems continue to evolve. So I watch the court docket. I'm watching the guidance from regulators. I'm listening to what the case law discussions are coming out of other countries. For example, Uber, right? And the recent Uber case using the SCCs. And now we're going to get new SCCs. So, I mean, listening to all the chatter and putting the pieces together, along with using well-researched and trusted guides from other professionals through the procurement process, it'll help you choose better tools, but also look at the tool maker. Who's making that tool? Are they invested in constantly improving their tool? Are they asking you, how does this work for you? How can I make this better for you? Or are they looking for a quick exit so they can sell their tool as a widget to someone else and then they can go buy a yacht? That's one of the factors that I put into working with tool makers because I understand how tool makers think. And a lot of them are working to build a legacy. They see a problem, they know how to correct it, they're building and improving constantly. Every iteration gets better. And then you've got people who are building for an exit, and I don't deal with them, right? There are too many of those tools that are out there right now. So just in terms of generality, I think it may be useful since we're talking about not all machine learning is, Gen AI kind of discussion. I just want to go through the Colorado AI Act definition for a couple of terms that they have here. A artificial intelligence system under the Colorado Act is any machine-based system that for any explicit or implicit objective infers from the inputs in the system received how to generate outputs, including content, decisions, predictions, or recommendations that can influence physical or virtual environments. That's what they call an AI system. It's very, very broad. It includes the recommender systems under ML. It also includes the foundational models under high-risk artificial intelligence system. That definition is any AI system that, when deployed, makes or is a substantial factor in making a consequential decision. There's that magic phrase the lobbyists want to throw in there, right, as a smoke bomb of confusion. But the consequential decision is defined as any decision that has a material, legal, or similarly significant effect on the provision or denial to any consumer or the cost or terms of education, enrollment, or opportunity, employment, financial or lending service, essential government service, healthcare services, housing, insurance, or legal services. Those are what they're considering consequential decisions. So recently, when Deloitte was found to have botched the AI system regarding government benefits in a couple of states, Tennessee being one of them, it was found that they had done this over and over, and they have contracts with over 20 different states. So Deloitte has been doing this for quite a while. These are high-risk systems. These laws were not in place yet, and they just ran right into whatever looked like they could advise people on. And the tool was absolute snake oil. These are the people in our safety net, our social safety net, disability employments, people that are disabled and cannot work. They're in the street. They cannot buy food. Their benefits were denied by a snake oil system that Deloitte is charging, millions of dollars to oversee. So now the harms are clear to people about why we need to get into these tools and make sure they're supervised and remediated. Because whether it's a consequential decision or not, people's lives are at stake here.
I'm thinking consequential. risks could have a broader scope than, impacting fundamental rights and freedoms in the EU, in the EU framework. I think the scope, it sounds to me like it's wider. But and it also means that all of these tools that we're applying to marketing, for example, we think they're constrained to marketing, but very easily they can spread into, applications of consequential impact and then become high risk. So they do need to be properly assessed. Even though we think we're only using them for marketing, maybe what we're selling is going to fall within the scope.
Yeah, I explain it to people this way. If I apply for a job, my likes, my swipes, my kinks on Pornhub, the contents of the shopping cart on Amazon, none of these things should have any bearing on whether I am qualified to do the job that I applied for. Yet, that information has been cooked in to the identity graph. It's there for a candidate profile. I've been scored and ranked and maybe even discarded and digital exclusion. So I no longer have the opportunity to compete for a job because they didn't like how much gin I drink every month or whatever. It's none of your business, but also it is reinforcing the systemic racism and discrimination that we still have residual in our society, right? How many women do you see in leadership positions at law firms around the world? How many? Women have outnumbered men in the legal system for years now, but how many are in power? That's just one power imbalance, and that's how it comes about. It comes about by, oh, I'm not able to apply for this job. Well, who is?
Yeah, so let me wrap it up with something even more practical, right? So now we have all of these Gen AI tools. Now I'm finally going to land on AI, on Gen AI and chatbots. All of these companies are deploying chatbots. It could be even smaller companies that are relying on again, on AI powered, Gen AI powered tools. So you deploy a chatbot, or your copy, so your, the content that you generate is being generated by any of these tools. There's so many out there. There's like, again, hundreds of AI tools, many of them built on top of the OpenAI or Anthropic or Llama, models. So how will you go about that?
Oof, transparency in Gen AI is kind of garbage. Like OpenAI is a closed model. Like, where's the transparency there? So, when looking at these issues, here's how this shows up. I see a chatbot on a property and I want to talk to the site owner, the business, and say, I see your chatbot. Can we talk about your chatbot? And they say, oh, yeah, it's great. It's got our logo on it and it says it's a chatbot, so everybody knows it's a chatbot. But underneath it, underneath the hood, at any one time, it could be Claude or a Lambda or a GPT rotating foundational models. And so that's how we go about it so that we can offer a variety of conversational topics. And I'm wondering, do you really need to spend all that quality time of engagement that you have with a live human? Like, do you think you would raise your conversion rate if you had other options for that human other than your chatbot? Because I see a chatbot is, what hours of operation do you have? Where can I look at your privacy policy? Or, who is the CEO of your company this year? Those kinds of general information questions. But if it's, I have a problem with my policy and you are denying my medical claim and I'm here at the hospital with my kid, can you get me to customer service? I just don't know that that is the right use of a chatbot. Like, chatbot does not mean get rid of humans and save money because you've got the chatbot doing it. But in terms of compliance, how do you go about doing that? Because you do have obligations to do a privacy impact assessment on that. And so at any one time, whatever I put into the chatbot may be shared with one of three or all three foundational models. Right. And so, yeah, it was easy to set up, super easy. Just like Chrome developer tools, those are super easy to use if you want to build an app and monetize it with ad tech. If you want to build an app that is not monetized for ad tech, you're going to have a hard time trying to find some tools to do that because it benefits the maker of the tool to use it that way. So now it's a mind shift that we need to turn around and say, let's stop trying to make everything easy for the business, because if it's easy for you, It's coming at some expense. And whose expense? The consumers. And the consumers are done.
Last thing, how can you even attempt to be transparent as a business using something like a chatbot? I've been approaching a few of them, and it's so hard to tell that they are simply sitting on top of OpenAI or on top of Llama. That's the basic sort of effort in transparency that I'm expecting if I'm going to buy the tool. How can I be transparent with my consumers if the tools that I buy are not even straightforward with me?
That was definitely in the mind of, in the discussions, in the trilogues of the regulators who are putting together the EU's AI Act. You cross the line in being a deployer if you wrap your logo around it and it's sitting on top of chat. You become a deployer and you now have additional obligations. And so, there are more disclosures. So you have more disclosures, but also you have obligations. If you find that your tool is harming humans, you have to tell somebody. Right? So, I mean, those sorts of personal accountability, transparency is one thing. Accountability is the next thing. Cost of forgiveness, that's what you're trying to avoid. So if you take care of step 1 and 2 as best you can, you shouldn't have to deal with step 3. Now, having said that, I will remind you, the majority of contracts and notices written are never tested, whether they be garbage or not. They're never tested. And so they must be fine, right? So, I see it all the time. Consultants will throw a bunch of language that they say you need and everything's just fine. And they've never even taken a walk through the tool. So, I mean, that's, in theory, yes, if you're a gambling person, yes, you can put your money on that. But if you really want to know for sure, then it's kind of a Hail Mary right now that you put in there as transparent as you possibly can be to notify people of your tool. This is the tool that we're using. They tell us these are the tools that they're using. Here are the links to their privacy notices if you have questions about it, because you don't want to tell consumers that I asked OpenAI and Sam Altman told me to pound sand when I asked for the model weights. Like, it's not something you want to put in your disclosure notices, but you do want to tell them as much information as you have and then give them opportunity to go to other places and find out what's going on. I expect that will change soon, because as these agreements get tested and more transparency actually becomes a reality, I think that it's going to be easier for businesses to say, I need you to give me this documentation so that I can properly advise people and not have liability for this if I'm going to use your service. Because if you're not going to be transparent with me, I can't explain how my AI works, and I'm not willing to accept liability for you just for the privilege of using your shiny new tool.
Yeah, and how they've been trained, because there may be even copyright issues sort of spilling out.
Absolutely, copyright issues. There are 30 cases right now approaching discovery on copyright issues and AI. So move fast, steal things. Yeah, but move fast and steal things, I think, is what they're doing now instead of move fast and break things. So, but I think that's going to come to an end pretty soon. What we are all trying to get to with all of these regulations is fairness. And fairness was not something that was considered during the blast of innovation. Everybody had such a great time on that ride. It was a wild ride. But now we need to look back and find out, where is fairness? And that's the privacy by retrofit that we all need to engage in.
Heidi, thank you very much. Thank you.
Thank you. Thanks so much.
Okay, that's all for today. Please follow the Masters of Privacy channel on LinkedIn if you want to find some interview transcripts, cheat sheets, and other useful resources and surprises every now and then. On top of that, episode notes and other feeds are available on mastersofprivacy.com. Thank you for listening.